Welcome to Indiana News Desk. I'm Joe Wren. Well, we're still several months away from the start of the 2018 legislative session, but a group of advocates is already working to gain support for redistricting reform. The effort died last year, and as Sarah Whitmire reports, advocates are hoping citizens will put so much pressure on lawmakers this year that they will have no choice but to take up redistricting reform.
Lawmakers spent nearly 2 years in a study commission on redistricting reform. The end product was a bill to create an independent redistricting commission that would draw legislative maps. But when it was introduced at the State House in February, the House Elections Committee Chairman Milo Smith refused to let lawmakers vote.
He had problems with the bill, even though 300 citizens showed up that day and we had 90 minutes of testimony. He said, I don't like all of this bill. I'm not even going to let it get a hearing.
Lawmakers still have a couple months before they file any bills, but Vaughn helped lead a rally at the State House this week for redistricting reform.
Go, hey, hey, ho, ho, gerrymandering's got to go.
She wants enough citizens to reach out to their lawmakers that it will be impossible for them not to do something in this upcoming session.
So if it's going to happen, our state legislature will have to pass a law to make it happen. They will not do that without tremendous amounts of pressure from citizens, from their voters.
One issue is that a lot of people don't understand redistricting. Vaughn cites numbers that show as many as 80% of people don't understand the basic idea. Simply put, redistricting is the process of redrawing electoral boundaries. It happens every 10 years. The problem is the legislators can redraw those lines to protect incumbents or a particular party. That's a tactic called gerrymandering. It's why some districts look like this. And this.
And House District 40.
This weekend, Vaughn and members of the League of Women Voters walked a nearly 2-mile route along lines that separate 3 districts on the southeast side of Bloomington.
It's an odd little shape in our districts where 3 districts come together. It is better for the voter if it's a nonpartisan issue or a bipartisan issue, so that whatever party has the majority vote doesn't get the say over how the districts are drawn that will affect the next 10 years of voting.
In 2014, Indiana had the lowest voter turnout in the country. Fewer than a third of people went to the polls.
When both parties compromise, all Hoosiers win.
If people go to the polling place, there's only one name on the ballot to choose from. They don't really have a choice.
Carrie Hamilton is a Democrat representing District 87 on Indianapolis's north side. She says the lack of competition makes people feel like their vote doesn't matter.
People are less likely to show up at the polls the next time. It's very hard on our democracy from a voter turnout perspective.
For Indiana News Desk, I'm Sarah Whitmire.
There is a case set for argument before the Supreme Court on October 3rd that deals with partisan redistricting. It comes from Wisconsin. Steve Sanders from the Indiana University Maurer School of Law joins us now. Thanks for being here.
Sure, my pleasure.
I know this can get complicated, but it's the Gill versus Whitford.
That's right.
So. What's so important about this case?
Well, so I think the Supreme Court is generally pretty hands-off with the political process. The idea is there's law and there's politics. But I think lower courts, scholars, and even some justices over the years have had the instinct that sometimes gerrymandering can be so bad and so severe that it ends up being a form of intentional government discrimination against people with a particular party affiliation. So this case is an attempt by the court to figure out, is there a workable test to determine when gerrymandering might actually cross the line and become a constitutional problem?
So why did they choose to take this on? Because this is not something that usually the Supreme Court would take on, right?
Well, the court has dabbled with the issue. About 13 years ago, they had a case where they essentially reached a stalemate as to whether a workable test could be found. This is a fairly high-profile case out of Wisconsin. It presents a really extreme set of facts where the state is very closely divided, yet the legislative apportionment is very lopsided. And so the court may have thought this case presents a good vehicle either for deciding, yes, gerrymandering does violate the Constitution, or it's possible that a majority of justices will say, no, this isn't just something that judges can decide. It needs to be left up to the political process.
Are there any possible outcomes that you can think of from this?
I think the only thing we can predict at this point is, as is so often the case, Justice Kennedy is likely to be the swing vote. That it's probably going to be a 5-4 decision based on an initial ruling the justices made allowing or not requiring Wisconsin to do anything at this point. Some people think that might be a prediction that the people who are challenging the gerrymander may lose, because the court has sent some signals already that it's not overly troubled by what's happening in Wisconsin.
All right, we'll have to wait and see. Thank you very much.
Thanks, Joe.